gentlemen, I would now request Mr. Tawhid Alam Lashkar, the faculty of Ajmal Law College, Hojai, to come forward and present the brief addressing about today's mock court.
With regards to the integrities of a moot court competition and how a moot court competition is held, and to make it very simple for everybody to understand and witness history, which I will repeat in my course of my speech. And therefore, I would like to state that we all are aware of the very basic fact that in any case there are two parties. One party is the victim and another side is the accused person. Similarly, in this particular setup today, we have two parties. One party is the victim side and one party is the accused side. For the victims, we have three of our esteemed advocates who are students of Ajmal Law College, and they will be presenting their arguments in favor of the victim. On the other side, we have the accused side who have been alleged of an offense, and we have another three advocates who will defend the side of the accused person. Moving ahead, we will have three of our esteemed judges, and we have our two court clerks. The judges will carry out the entire proceedings of the entire setup. What the audience will be able to witness as a legal revolution starting from this particular platform will be, they will be able to witness how an examination and cross-examination of a witness is being done, which is one of the very essential principles of entire legal curriculum or criminal advocacy. Second, we will going to see the technicalities of law, how the sections are interpreted and how advocates argue in the real court. And therefore, we have today a setup of trial advocacy moot court competition. Let the floor open for the audience to witness history, and also I invite the judges of today's session to preside over the proceedings and call the court to order.
I call the court to order.
The council seeks permission to approach the dais.
Granted.
Much obliged. The council seeks permission to address the bench collectively as Your Honor. Much obliged. Your Honor, in this case of GR 145/2022, today is the date fixed for hearing, and I and my co-counsel shall be representing the victim, and necessary witness shall be examined in order to establish the case of the prosecution. Your Honor, at the investigation stage, the police has arrested 5 persons, including the FIR name accused individual Mr. Mehrajul Alam, along with his son Mr. Anas and his friend Mr. Rahul Chetri. The accused were denied bail by both the Court of Sessions and the Honorable High Court. The case of the prosecution is such that on 10 August 2022 at around 1 p.m. in the afternoon, Mr. Mehrajul broke into the private property of Mr. Yusuf and started to hurl abuses accompanied by him, his son and his friend Mr. Anas and Rahul Chetri respectively, and started to hurl abuses and provoke him. The core issue of this matter is that Mr. Mehrajul owns an adjoining property that shares the boundary with Mr. Yusuf. As per the record, the total land owned by the Mr. Yusuf is of 2 bighas.
Your Honor, we have strict reservations in this measurement and we want to put this on record at the onset that we contest the claim of 1 bighas, whereas in actual view the complete 2 bighas we shall be proved accordingly.
Indeed, Your Honor, we shall go into that matter subsequently. The gist of the matter is, firstly, more than 5% confined trespass into the private property of Mr. Yusuf, thereby attracting section 450 of the IPC, which is punishable with imprisonment for life. Secondly, these people were constantly trying to take the life of Mr. Yusuf, his wife and his brother, thereby attracting section 307, that is attempt to murder, and 339, that is causing wrongful restraint in their own houses. And thirdly, causing grievous hurt under section 320 and any other charges as Your Honor may deem fit above the courts of hearing. That's all now for Your Honor. Now I'd like the court permission to call my co-counsel over here.
Your Honor, the actual facts are such that Mr. Yusuf has encroached 1 bighas of barren land which was left over as an open area which belongs solely to Mr. Mehrajul Alam even before he could put a boundary over his property. So when Mr. Mehrajul Alam took the measurement, it came to his notice that Mr. Yusuf has already put up a boundary over his property. So when Mr. Mehrajul confronted with Mr. Yusuf, he started giving him threats and wanted to hit him with an iron rod. So in order to save himself from the attack of Mr. Yusuf, Mr. Mehrajul took hold of himself and said,
Your Honor, what is shown as self-defense is actually a pre-planned, well-articulated attempt to murder Mr. Yusuf and his family. And if this court doesn't take the claim seriously, it will amount to gross miscarriage of justice, and these kinds of acts will keep on increasing within the society. And it won't be very light, Your Honor, like when your and my houses too will be under attack. And therefore, to prove my facts in details and in proper order, I would like to seek your permission to call our first witness, Mr. Yusuf Khan, who shall be the prosecution witness number 1. Permission granted. Much obliged, Your Honor.
Prosecution witness number 1, Mr. Yusuf, called to the witness box.
Or give to this court shall be the truth, the whole truth, and nothing but the truth.
Mr. Yusuf, can you please tell the court that who are the people who attacked you?
Mr. Merajul Alam, his sons, and some other hired thugs attacked him.
Objection, Your Honor. The prosecution cannot malign the reputation of the defense by calling them thugs and giving them names. After all, they are the reputed members of the society.
So tell me, Mr. Yusuf, have you received any injuries?
Yes, madam. I was severely injured and I was admitted in the hospital later on.
Honorable, please note that the prosecution witness has finally agreed that there was indeed some phone calls and which implies that Mr. Yusuf has invited Mr. Merajul to come to his house and then just tried to attack him. And this shall be put to record, which I shall use at the later stage of my argument. That's all, Your Honor.
Okay. Prosecution counsel, do you have any further question for prosecution witness 1? No, Your Honor. However, we would like to call our next witness. So, were you in the house on 10th August 2022? Yes, ma'am. On 10th of August 2022, I was at home along with my husband and my brother-in-law. Okay. Can you please explain to the court that what exactly happened on the day of the incident? On the day of the incident, that person named Mehrajul Alam, along with his son Anas and some other persons whose name I am not aware of, came to our home and attacked my husband, and they also caused brutal injuries.
Your Honor, may please take note of the fact that on 10th August, they claim to have been attacked brutally. But they don't go and see the doctor on that day. Rather, they realize that they shall go and see the doctor the next day. This itself raises a suspicious nature.
Objection, Your Honor. Violate the time. Order and not relevant. Defense counsel is just trying to divert the attention of the court from the core issues.
Objection overruled.
Can you identify any other person who were along with Mehrajul?
No, ma'am. I cannot identify any other person except for Mr. Mehrajul and his son.
That is the wife of the informant. Does not even remember the name of the accused, neither can she recognize the face of the attackers. This is extremely
Objection, Your Honor. Point to be noted. As the victim has already identified the accused in the examination in chief, Mr. Mehrajul Alam and his son and his friend Rahul Chetri. I don't know what kind of suspicious does
Of course it is suspicious in nature, Your Honor. Of course it is suspicious in nature, Your Honor. Even after so-called traumatic incident, even a small child can remember the face of the attacker, then why can't she remember the face of her attackers?
Prosecution witness number 4, that is the investigation officer of the case. Permission granted. Much obliged, Your Honor.
Prosecution witness number 4, investigation officer, called to the witness box.
Order! Maintain the decorum of the court.
I was the investigating officer of the case.
Defense seeks permission for cross-examining prosecution witness number 4.
Defense will proceed with the cross.
Much obliged. So, do you remember who called you to give you information about the incident?
No, I do not remember him.
When you reached the spot, did you find any kind of physical fights going on there?
When I reached the place of incident, the fight was over already.
If you have not witnessed any fight, then how can you draw the conclusion about the same?
I seek narratives from the neighbors and other eyewitnesses who confirm the incident.
Second witness, as mentioned by our investigating officer, and secondly, it was Mr. Yusuf who has phone called Mr. Merajul and invited to him in his house. That's all, Your Honor.
Miss Prosecution Counsel, do you have any other witness to prove the case of the prosecution? No, Your Honor, that's all.
Is it a fact that on 10th August you attacked Mr. Yusuf?
No, this is not a fact.
Is it a fact that on 10th August you along with 10 to 15 other people entered into the private property of Mr. Yusuf and you have tried to attack him?
No, this is not a fact.
Did Yusuf invite you to his house to enter this house with iron rods and other weapons?
No, I didn't bring any weapons with me.
No, my question is, did Yusuf invite you to enter his house with iron rods and other weapons? Just answer what is asked to you.
Absolutely not.
Absolutely false. Your Honor, if he has not carried the weapons in the Yusuf's house, then how did the police recover the same from the crime scene?
Objection, Your Honor. How can the learned counsel be so sure that the weapons were carried by Mr. Merajul? Nothing related to the weapons have been proved so far.
Are you very close friend of Merajul?
Yes, I am very close friend of Maryam.
Why did you go to visit Merajul on that particular day of the incident?
In Merajul house to see the construction work of his house.
Why are you called for a planned attack on Mr. Yusuf and his family?
No.
Absolutely false. You are called for
Objection, Your Honor. This is again
It is
intimate
not a
witness.
coincidence that you are present on that day.
Objection overruled.
Did you not go with your weapon to Mr. Yusuf's house and his family?
No, I didn't carry any weapons.
Did you not hit Yusuf and his family?
No, but we faced several injuries.
So such a nice storytelling, Your Honor.
Your Honor, it is very important to note that the case of the prosecution suffers from lack of evidence, and secondly, they were also unable to establish their case beyond reasonable doubt, which is the core necessity for conviction in any criminal offense. The case of the prosecution rests upon some objectionable grounds, which includes that there was intended invitation from the prosecution side and thus trespass is not attracted. Secondly, that all the attacks of the defendant was just a reply of self-defense and thus no case is out against the accused persons. That the wife of the informant does not even identify the accused person. Fourth, that the medical assistance was taken only after some reasonably suspicious period has crossed. Last but not the least, Your Honor, if the investigation officer has not mentioned any independent witness, how can we say that this case is a relevant one? अगर कोई स्वतंत्र गवाही ना हो, Your Honor, how can we say that this case is a relevant one? This is a grave irregularity from the inspection officer, Your Honor. So, thus, Your Honor, the defense humbly submits that the very basic and essential requirement of criminal law is that the case of prosecution shall be proved beyond reasonable doubt, which has not been proved in the instant case. With this, I conclude my case here. Much obliged.
The court has heard both the prosecution and the defense side. The judgment is reserved for the next day. Till then, the court is adjourned.